Live stream. Okay. Hey, welcome to Probate Weekly. I'm Bill Gross, the LA probate expert amongst real estate agents. But today we have a real legitimate probate expert, as proven by the stuffed animals he keeps in his office. I'm excited to have with us today an estate planning attorney, and I think arguably one of the best, one of the most well-known, certainly by amongst my colleagues, thought of as to be the best, particularly with high net worth individuals, estate planning in Southern California, Jeff Condon. Jeff, how are you doing today?
I'm doing pretty good, Bill. Just to get this out of the way, the reason for the stuffed animals is because these stuffed animals happen to be in my office. I'm a big Snoopy guy. Got Snoopy art all over the place. And you know what? If I don't have these stuffed animals with me in this presentation, then I just come across as the normal, boring lawyer who's clinical and has no vocal inflection at all. But with these accoutrements in the frame, I become the warm, fuzzy, and entertaining attorney, or at least that's the hope.
Well, and I know you, met you initially through a swim team. We both belong to, I think, the largest adult swim team in America. You swim with the fast guys down in the first lane in a pink Speedo. I'm at the far end with the people barely hanging on to the pool. But nevertheless, I used to see you more regularly pre-COVID. We swam a few days a week. I'd see you naked in the shower. It was one of the thrills of my life. And then since then, now, and then one day I saw you in court, all dressed up like an attorney.
No, not really. I'm dressed up. I was thinking, do I wear a tie? Bill, I don't think I've worn a tie for maybe more than a year now. So this is now formal attire. This collared short sleeve shirt. This is what I wear now. And when I meet with new clients, I say, the last thing I say before we leave the phone is just letting you know, I'm dressing casually. If that offends you, let me know. I've never had a response that said, yes, absolutely. How dare you? You better dress up. Never had that, close to that. In fact, the response I usually get is, hey, I'll be dressed casual too. So I don't think I could get away with this in New York, but here in Southern California, the beach culture, yes, this is par for the course.
Pre-COVID, I'd see you in court maybe once a week, and inevitably I'd be with another attorney or somebody else, and we'd say hello, and they'd say, well, how do you know Jeff? And I'd say, well, actually, I just swam with him naked. Yes. So, anyhow, so give us a background, Jeff. I know you're from the area, and I know your background, but you can share kind of with the people on the call today where you grew up, and then how did you get into practice of law?
Well, I was born and raised in Santa Monica. I still live in Santa Monica. I work in Santa Monica. I one of the last remaining true natives of this town. My father went to Santa Monica High School. My brothers did. I did. My kids did. So my kids are the third generations of native Santa Monicans. My father said to me, why did I get into the business? Well, I went into the family business. My dad is in estate planning. He was an estate planning lawyer. He died in 2006. But he once said to me, I said, as a kid, said, I don't want to be a lawyer. It's boring. And he said, okay, then, whatever you want to do, you should do. But just keep in mind that whatever you do, you don't want to have to count your pennies every time you want to take your wife out to dinner. So, and if you have a burning passion to do something, you do that. But keep what I said in mind about the financial responsibility. Well, I didn't have a burning passion to do much else except, I don't know, watch TV. And swim. So I said, okay, sure, why not? I'll go into law school. I'll go into family business. I didn't have any great passion for it, admittedly, but in the years since, the field that I'm in, inheritance planning, I really feel pretty good. It sounds trite, but it's true. I'm helping folks out at a time when they need that help the most. And that means when they're putting together their inheritance plan, when one spouse dies and I'm dealing with the surviving spouse and shepherding him or her through the process of inheritance plan, administration and distribution. And the same thing, what happens when the last spouse passes away and I'm dealing with the kids who have just lost their parents. And I feel like almost like a superhero, coming in with my specialized knowledge to help them through the myriad of legal and administrative things that have to happen and take place in order for a smooth transition of wealth from deceased parents to live children. So I know that sounds trite. And if I'm hearing that, I'm thinking, yeah, BS. But it's true. That's absolutely how I feel. I really feel like I'm making a difference. I'm not suing corporations. I'm not chasing ambulances. I'm really doing something that's helping folks out. So yeah, I think that's responsive to your inquiry, yes?
Yeah, well, and you doing that while surrounded with stuffed animals, I think is an important distinction to add in.
Well, like I said, I'm a big Snoopy guy. I've always been. So I've got, so which sure makes it easy for when my kids are buying me Father's Day presents and birthday presents. They said, oh, just buy him anything Snoopy. He'll be fine. The Garfield, I bought this for my grandmother on her 90th birthday. My grandmother died when she was 103.
Still kind of riding high now. We're only at like 500 million this year, so we're a little bit behind. Like he's struggling with that emotionally, and I'm like, playing violent.
What was that? Oh, but anyway, and this is kind of very random, but one of the things that I tell clients to do is if they have certain items they want to go to certain people, certain of their stuff, I say, put your intended recipient's name on a piece of masking tape on that thing, that item, that hutch, that armoire, that refrigerator, that clothes, that whatever. Well, my grandmother took my advice and she put my name on the bottom of Garfield here because I wanted it back after she passed. And you know what? She did. So this has been in my office since my grandma passed away in 2000 and whatever, 8. So that's why Garfield's here. Garfield's okay, but Snoopy's the best.
You got a bunch of Snoopy animals.
Can't hear you, buddy. There you go.
Whoa, can't hear me. I'll just say I was born in Santa Monica. I'm a native as well.
Yeah.
Though I take a bit about go a little deeper on the estate planning part. Basically, the goal is for you to help people accomplish their goal after they pass and protect themselves while they're alive and avoid litigation. What are some of the common mistakes you see people make when they come to you? People don't come to you, I don't think, initially as often as they should preventively. I'm sure you get people come to you and have a problem many times. What is the most common problem that people come to you with that you think would be preventable?
Well, that's I'm glad you asked me that. And I'm going to amend that a little bit in order to dovetail into my agenda, which is not diverting from your question at all, but it fits into something I wanted to say. Today, TikTok is really big, as you know, and one of the current trends on TikTok is when professionals or persons who are in business say the top 5 things they wouldn't do in their opinion as a person working in that business. So a medical doctor, a brain surgeon says 5 things I would not do based on my experience as a brain surgeon, or for a who was the other day? 5 things I would not do from a person who's a real estate broker or whatever thing. So I wrote down 5 things that I would not do, as a person well-versed in the field of estate planning. 5 things. And so you asked me about what are the common pitfalls or mistakes or problems. I wrote these down right before our meeting. First of all, and I'll just go through these real quick. Don't die with the child owing you money, because when you die, everything that you own passes to your children in equal shares in the main. And everything that you own includes the debt that one child owed to you. So now that debtor child becomes a debtor to his siblings or her siblings. And those siblings are going to want that debtor sibling to pay up. And there goes the family relationship. So don't die with the child owing you money. The second thing I wouldn't do is don't name just one of your children as the successor trustees of your living trust. the successor trustee's job, pretty much everybody's watching this has a living trust. The living trust provides that after you die, your children will come in and they will succeed you as your successor trustee to be the delivery boy of the assets that are in the trust to the beneficiaries who are set forth in your inheritance instructions in your living trust. And if you have 3 kids, your inclination is to say, too many cooks spoil the broth. I'm just going to name one of my children to be the delivery boy trustee to carry out my inheritance instructions. Well, I have learned that that's not the way to go. Efficiency does not always mean efficiency, especially in such a high, an emotionally fraught arena as the inheritance arena. Because if you just name one child out of 3 children to carry out your instructions, well, those cutout children may think, hey, mom and dad didn't think we were smart enough or to do the job, or that they didn't trust us enough to do the job, even if that was not in mom and dad's mindset. They're just thinking efficiency. Or the children out of power often contest the job that the trustee child is doing. Hey, I haven't heard from that kid in a while. Haven't heard from our sister or brother in a while. What's he or she doing? And, gee, what is he charging for his fees? And, whatever it is, it's unfair. And what attorneys are being hired? What accountants are being hired? What tax positions is he taking? Are they disadvantageous to us? There's just a whole bunch of, there's just a whole bunch of things that the successor trustee has to do in order for a smooth transition of wealth from one generation to the next. And if all the children, all the siblings are not involved in that, then that could run into some big time problems, especially if there is a vacuum of information. Because when you have silence, when you have a vacuum of information, then what's going to fill that vacuum? It's going to be suspicion. So don't, appoint all your kids as trustees of your trust, unless there's a good reason not to. One kid's on drugs, one kid you haven't talked to in 20 years. Okay, the next thing that I wouldn't do as an estate planning attorney advising a client is don't leave your children an unequal inheritance. Do not leave your children don't treat them unfairly. And unfairly to your kids means unequal. All right, well, that's easy. You say, okay, I'm going to leave my kids everything I have, 1/3, 1/3, 1/3. Okay, 3 kids, fine. You think that's equal, but equal does not necessarily mean fair if you, mom or dad, gave more to some children during your life and less to the child who has gotten the short end of the stick. From a parent's perspective, why should they care about that? They were helping a child out during their lives when that child needed help, financial help to start the business, put the down payment on the home, help their kid out with braces, pay for that wedding, whatever. The parents are saying, hey, we're helping out the kids when they need that help, and they're not keeping a scorecard. But the ones who are keeping a scorecard are all the kids. And if those children are not given the additional funds to make up for the gifts that the others got, then they perceive that they've been treated unfairly, and they're going to keep that in mind as they progress in life with their relationship with their siblings. I understand. I'm the first person to understand that parents really don't need to keep track of all the lifetime gifts they made to all their children. But my advice is, based on everything that I've seen and all the fallout that I've seen after parents die and children divide the money, that the parents should at least consider equalizing gifts that the parents made to more children than the others over their lifetime. Because if you don't, then it's quite possible that your children, who are the most precious possessions in your life, and you want to be sure to have a good relationship after you die, do not split up over this perceived unequal inheritance. So that's 3 things, Bill, 3 things of don'ts, and these are the biggest problems that I see in the inheritance plan. Just 2 more. I know I'm going on this soliloquy, but you got me started. So now you're going to regret your decision. 2 more. Don't allow your children to blow the dough. Don't leave them their inheritance in such a way that they will be in a position to, throw it in the street or lose it in a divorce, or, it all winds up with your son's widow's second husband's kids from his first marriage. You have to understand that when you leave your assets to your children, it becomes theirs. They can do whatever they want with it, but they can also lose it to all the risks in their life. So the parents have to account, and they have to, examine who are their kids. Are their kids responsible? Or do they have financial maturity? Are they in a business where there is a high malpractice litigation rate? So we take that information and we say, okay, maybe it's your children should receive it in a way that protects it from those potential risks of loss. Okay. And the last one is don't have an inheritance plan that allows more of what you own to go to the IRS than your children or grandchildren. And that's the topic of estate tax planning. Maybe not so relevant right now for most people who are listening to this or watching this, because right now there's an exemption from the estate tax of 12 million, which means you can die with 12 million, with less than 12 million and not your kids don't have to pay any estate tax. But that 12 million exemption goes back down to 5 million in 2025 or 6. The estate tax exemption is a political football. It's changed with every single presidential administration since Bush in 2000. It's the biggest political football I've ever seen. I've never known another tax or other law that has changed every single time there's a new administration. Yeah. So who knows, if you vote Republican in 2020, in November, maybe we won't have any estate tax, and therefore, exemption doesn't apply. But, chances are we'll still have a $5 million estate tax exemption. And if you die with less than 5 million, there will be no estate tax. But if you have more than 5 million, which is easy to do in Southern California with real estate values so crazy, then yeah, there are plans that we can be put in place where more or all of what you own goes to your children, grandchildren, and less to the IRS. Okay, now I'll shut up. And I'll let Snoopy do the talking. Snoopy has got a few things to say.
You're not going to shut up. I'm going to ask you questions and engage you in the discussion. So it's interesting that you're obviously very passionate about it. And that's what I admire. The side note, to me else on this call, one of my best friends has a life cast, and he and I were chatting one day, and he was so proud that he had a great guest who he called the best estate planning attorney in LA on his call. This is about a year ago. I said, really, who was that? And he said, it was you. And I said, well, that's funny. He's on my call this week too. So I think a lot of you, and I really appreciate your passion for your work, and I admire it, try to do the same thing in my work. It's interesting, of your 5 things, I think 4 of those I would call soft or non-technical legal issues. Legal, but the other 4 really are based on your personal experience in the field and your having to manage, I guess, the relationships separate from the law, or as the attorney. I don't mean to say it's not part of your job, but it is. So describe that a little bit. That's an interesting. It's just interesting to note. Your work is very sophisticated. I've seen you in court. I've seen you. This by your S4 are soft relationship oriented. Is that design? Is that something involved? Is that what you enjoy? How does that happen? Well,
that's very perceptive, Bill, because there are 2 sides to estate planning. Actually, I think estate planning is a misnomer. It really is inheritance planning, because people hear the word estate planning, they think, well, I don't have an estate, so I don't need any kind of planning whatsoever. Well, even if you don't have a house, you don't have real estate, you don't have much, you still have stuff and assets that you want to go to the next generation after you die. So I like the term inheritance planning. Everybody needs inheritance planning, but it's kind of like insurance. Everybody needs, insurance, whether it's healthcare insurance or life insurance, whatever, but not everybody has it. So I liken estate inheritance planning to that, but so I try to broaden the concept. And in inheritance planning, there's two sides to it, which you've already alluded to. You said that the first 4 are non-technical. the way I phrase that is that's the family side, the human side. The estate tax one, the fifth one, that's the money side. And the money, and saving estate taxes is the money side. Avoiding probate is the money side. And as my dad said, hey, a monkey can do that stuff. It just, push a few buttons, you come up with some plans to do just that. Reduce, avoid probate, save estate taxes, fine. It's still an important part. But I consider myself a student of my father. My father was the one who said, it really is the family side that becomes more important, just as important as the money side. And I already alluded to it, Bill, but people want to die knowing that the plan that they've come up with in their inheritance, in the inheritance plan, is not going to do harm between their families. I mean, maybe their kids are already estranged, maybe they don't talk to each other. But in most situations, the kids are friendly. They chat, they talk, they get together maybe for Thanksgiving, Christmas, and all is well. But they don't want to create a divisiveness or a conflict or chaos into that family unit by making inadvertent plans in their inheritance plan, making an inheritance plan that inadvertently creates that conflict and divisiveness that not only will separate their kids, but will also go down to the grandkids, because the grandkids won't, on all the factions with all the siblings, they won't even talk to each other. And a lot of times they don't even know the reason why. So we've seen enough of that divisiveness over the plans that we came up with over the years as a result of not knowing what we didn't know. We said, gee, okay, yeah, it sounds fine. We'll just leave everything to the kids in equal shares. Great, basic plan. But then we saw the fallout that took place when these kids who got an equal division started accounting for the lifetime gifts that they got from mom and dad during mom and dad's lifetime. And when that scorecard wasn't equal, boy, did we see some emotional fallout as a result of that separated those once close kids. And we saw that repeat itself over and over again. And we saw the situation where the son inherits, the daughter inherits, they put the assets that they inherited into joint names with their spouses, and then there's a divorce, and then the spouse walks away with, the former daughter-in-law, son-in-law walks away with one half. Or as I mentioned, if son, loves his wife, puts his name on to the inherited assets jointly, and then son dies, it all goes to the wife, she remarries, and it ends up with the kids of her second husband. So we've seen all these things, but it took a long time because in the first, 20 years of my dad's practice, didn't have a lot of clients die. But when I came into the practice, I don't think this was, there's an association to this, but, clients started dying in volume.
I will pick you up with one hand.
Yeah.
By your tip.
Who's that guy? So
body slam your ass. And when I'm standing on top of you and you're like, and I'm grabbing you.
Okay.
Okay. Well, that's Andrew Tate. Nice. So anyway, so we saw these things happen, and these were things that inadvertently took place in, that were not intended. I think what do we call it? The law of unintended consequences. Well, these were the unintended consequences. So now the books that I wrote, they're full of cautionary tales. It says, hey, we saw this because of a plan that we happened to screw up on because we didn't think about it. But now that we've seen it, we've seen that the plans that we created years ago inadvertently created chasms in the family. Now we say, hey, now we recognize that potential issue, and now we can come up with plans to resolve those issues. So family side, the blood side, keeping money in the family bloodline, making sure that the family plan, the inheritance plan, does no harm, just as important, if not more important, than the money side. Very, very perceptive, Bill. Good.
And it's interesting. I'm a big advocate that, and I know we may disagree on this, but just from a business point of view, wow, look at this. Somebody's blown up the chat box too. Andrew Tate, man, is a bad guy. That's a shame. hold on one second here.
I'm going to leave Andrew Tate everything. I'm going to make sure that all my clients leave Andrew Tate everything that they have. Yeah.
He just got reported, so he's gone, and we will. So what I was gonna say is, that's so aggravating. Where do I want to go with this?
I don't know.
So
can we
so
talk
I'm
about
gonna
swimming instead?
advocate
That's more exciting.
from a business point of view, not from a legal point of view, but from a business point of view, I would say that a good chunk of people are better off with a almost bad estate plan than no estate plan, right? If you have a probate court versus probate court, at least you have an estate plan. I don't know, 8% of the time will stay out of court. It may have all the soft problems you discussed, but you'll avoid probate court as a place to solve them. But what I also have figured out in talking to you is that sounds good, but 10, 20 years from now, when these boilerplate companies' estate plans come to reality, it's easy to write the plan and take and cash the check. What's harder is, well, how do people deal with it when the plan goes into effect? And that's the part, that's the challenge, right? So, and I'm sure one of the way you see that. So I would just say, or let me ask you, for people who can't afford a
Can't afford. Ooh, you got stuck.
proper attorney sit-down consultation. There are cheap plans. You pay for it. Do you see them as better than nothing? Do you see them as counterproductive? What do you, for the modest family that maybe just it's a stretch, mom or dad are failing of health, they want to get something on the books. What do you recommend to people in that position? You just can't really.
Well, this is another relevant matter you've brought up. Just this week alone, I have seen I've seen folks, and by the way, any inheritance planning attorney, any attorney who does what I do, should not charge for that first consultation, whether those folks don't have a plan, whether they do have a plan, and the attorney's job is to review it and talk with the client to see if that plan is still relevant. That consultation should be free. Because out of necessity, even if it's not out of one's good grace, because I don't know what kind of job that I need, that I'll be doing until I see what that plan is and I talk with the clients. I can't quote a fee until I know what the work is going to be.
Right.
So I think out of this necessity, that has to be that first consultation has to be without charge. So that's the first thing. The second thing is that this week alone, I've gotten 2 new pieces of business, which involve slimming down and simplifying inheritance plans. These happen to be living trusts done by the same, push a few buttons company, one of those volume produced living trusts that is just too sophisticated for the facts at hand. So, they said this week, they get, a ton of documents. The clients have never read it. They don't understand it. And it takes me 5 minutes to go through it to the greatest hits and say, this is what you got. And they say, no, that's not what we want. Or if it was something they wanted to go, that doesn't apply now. So they got to come to someone like me and they say, okay, what will you charge to amend this? Sometimes just redo the whole thing. So then I quote a fee, and that fee is a flat fee. And the flat fee means that they don't have to look at their watch every time they talk to me on the phone or email me or meet with me or to discuss changes, because that's what the flat fee is. And the flat fee is based on the work that is based on what their needs are and what their needs are not. One of the reasons people hate lawyers is that we have to charge for our fees. We have to charge for these services. I get it. A lot of times, people's first experiences with a lawyer is when they come and talk to someone like me, who's going to now do their inheritance plan or change it up, or the second lawyer they've seen because they saw somebody else prior to me to do their inheritance plan. They've not been divorced. They've not set up a corporation. They haven't set up a business. They haven't been charged with a crime. So they're seeing someone like me, a guy with Snoopy all over his office and who's wearing, green collar shirts, but so, I try to be competitive. I would say that 70% of the people that I see for flat rate trust work, whether it's a new trust or whether it's an amendment or a restatement of an existing trust, I say 70% fall somewhere between 2,000 and 5,000. And the other 30% could be below that or above that. And, a lot of people say, well, is it based on a percentage of the assets? Absolutely not. I've done inheritance planning work for clients with 20 million, and it cost $2,500 because it was very basic. On the other hand, I've had some clients who have just had massive sophisticated inheritance plan instructions, and all they own was a house. And I've charged $20,000. But in fact, with those kinds of clients, I try to quote more than what I think I should be charging so that they'll go away, because they're just, it's just counterproductive to have such a super sophisticated Star Wars plan for a simple house that they want to keep in the families for generations and generations and generations. They want to be sure it's not sold, and they have to account for all of these different rules and regulations. So sometimes the clients surprise me. I charge a fee. I quote a fee to hope that they will say no, but they say, yeah, sure, let's do it. So I don't know how that makes people perceive me, but whatever floats people's boats. I'm happy to do. This is what I do, and I'm their wish is my command, but it's my job to advise them if something is overly complex for the situation or needs more complexity for the situation. Okay.
Another reason. I appreciate that, because there are times that might thought it would be worth your time. So it's good to know. Jen has her hand up in the chat box. Let's go ahead and get her unmuted. And she got her video on. Jen, what's going on with you?
Can you hear me now?
Yeah. Hello.
Okay. Hey, how are you?
Hey, have you been staying awake during my diatribes here?
Yes, my dad was a lawyer, so
okay.
It was yeah. So anyway, I'm a realtor. I've been one for 26 and a half years. I'm in the Atlanta market. So, but I used to live in Manhattan Beach. So, many years ago. So that was my California time. Question for you. The other day, somebody was talking to me about a legacy trust. I have some stock in a bank here in Georgia that's going to be selling. My husband's company. We're getting ready to come into some things. Our kids are in their 20s, and I'm also doing a lot of probate and estate stuff. Just it's fallen into my lap, so it's like I think I'm going to kind of go into that direction. Tell me like I said, somebody mentioned a legacy trust. Can you talk a little bit about that? Just general high.
Okay, well, I have to make an assumption that the legacy trust is another name for a type of trust that is fairly common, but somebody just happened to call it a legacy trust. I'm perceiving that trust is a type of trust where property goes into this trust. Trust is like a bucket. It's in this bucket, and the persons who have established this bucket, they're the settlors. They own this property during their lifetime. They can do whatever they want. But when these settlors die, the inheritance instructions in that trust document say something to the effect of, this property shall stay in trust for the rest of our children's lives. And during our children's lives, here are the rules that apply to this trust. Sometimes it'll say that the property can't be sold. Sometimes it'll say if it is sold, it must be used to purchase another property, or it'll say, it will say, and while the property is still intact and in this trust, it can be rented out, and the rent will go to the children in equal shares, or it will say it can provide to be a principal residence of one of our kids or most of our kids, and we have rules about who can live there at what time and should they pay rent. So you have this property in this trust that's got all of the instructions that by which the trust has to be administered and held and distributed, that the property is. And then it says, okay, when the last of our children die, well, now what? Well, this if the persons who set up this trust says, we want this property to be the pyramid to our future generations, well, that property still may be considered untouchable while it's in the hands of the grandchildren. So now maybe the grandchildren can't sell it, or the grandchildren can charge rent, whatever. Now these rules and regulations and do's and don'ts apply to the grandchildren. Okay, that could be in the form of a generation skipping trust. It could be in the form of this legacy trust or what have you. But I think that's probably what do you think? Does that kind of sound like what you're understanding what that legacy trust is?
Yes, and that they could almost generation skip. That was one thing he said about it. The other thing was that there was some tax benefit to using this specific trust versus just a regular.
Yeah. Okay. Yeah.
So that was that.
Yeah. Well,
Pay the IRS less money.
Yeah, the tax benefit would be that if this was a generation skipping trust that has all the required bells and whistles that the IRS requires requires to exist in order for it to be considered a generation skipping trust. The benefit of that is so that when the property goes from, so here, mom and dad die, property stays, goes in the generation skipping trust. The children of mom and dad are the beneficiaries. So when those children die and that property or the sale proceeds therefrom or whatever's in that generation skipping trust will go to their kids with no estate tax.
Okay.
No estate tax. So, my dad used to say there's no second bite of the tax apple, because maybe there'll be an estate tax after mom and dad are dead when the property goes to the generation skipping trust. Well, the purpose of that is to avoid that second bite of the tax apple on the same property when the property goes from those deceased children to their children. That, I think that's maybe what you're referring to.
Yeah. Just no double taxation.
Correct. Yeah. No second bite of the tax apple. Yeah.
Thank you very much, Jeff.
Sure. That'll be $12,000.
Checks in the mail.
Fax it to me. Fax me the check.
So Jeff, you have some fans here. Scott was on the call the last time you were on my show and said last time you're getting ready to have surgery on your shoulder, and they're wondering how your shoulder is. So I've seen you in the pool. I know you're back in the pool. How is your shoulder? Hello?
Who's that too? Who's that question for?
Scott is on the call, and he's asking about your shoulder. How's your shoulder? You had surgery on it about a year ago or 6 months ago?
I don't see this guy.
Well, he's not in. I just it just says comment in the chat box.
I didn't see a chat box. Okay. All right. Okay. God, now okay. I thought maybe you were referring to, I know you couldn't have been, but about more than a year ago, I was running with my dog, fell down and had the first fractures of my life. Fractured rib, fractured radial, elbow, a radial neck fracture. God, that was horrible. And the first thing that I thought of when I went down was, how is this going to impact on my swimming? That's the only thing I could think about. So there that is.
And the answer is?
Yeah, well, I refused to let it take me out of the water for too long, and I got back in too soon, and I re-injured my rib, and I became Mr. Peloton for a few weeks after that. And then when I got back in, I was just doing one arm swimming and kicking, and just like anything, you just gotta keep at it. Don't get too demoralized. Because I was really at, I thought, relatively high level before I went down. Well, I come back, and then I got sick again. And then earlier this year, in May, when I got back in shape, I got married, but that required a honeymoon abroad. So didn't really swim too much there. And when I got back, I tested positive for COVID. So I was out I really wasn't swimming there for 3 or 4 weeks, and, came back slow, but I think I'm doing pretty good now. But I think I may have lost 5 seconds, which, and civilians will think, well, that's not so bad. But as you know, civilians meaning non-aquatic people, but as you know, Bill, that's huge in the water.
Right.
Yeah.
Especially at your end of the pool. My end of the pool, it kind of gets mixed in. Your end of the pool, that's a couple lanes you're talking about. That's very competitive. It's a very big, who's talking about it. It's a big deal. So
it is, especially if you're in a competitive lane and you don't want to, and nobody, and Bill, nobody wants to lead. I lead because I have no problem leading, zero. I am happy to lead because I know that at least the only one interfering with my own workout is me, but that's become a default over the years because nobody wants to lead. But so if I'm leading, I got to maintain that lane 2 position and not fall back, so, if I got to do a 120 base for yards because the people behind me are doing 120 base, that puts a little more pressure on. But I do, I'm not saying I like the pressure. Actually, not the best part about the workout is when it's over. You
always tell me, have fun. I go, it's not fun. There's nothing fun about it. I like how you feel afterwards. It's really not fun. So.
Getting up at 4:40 in the morning to get in the water at 5:30 is not fun. Getting immersed in water at 5:30 is not fun. So, but what's fun is when it's over and you feel that sense of accomplishment so early in the morning and you have the rest of your day. That's fun. So I've since become OCD about it. If I don't get that morning swim in, then there's something off. There's something wrong. So unless I'm on vacation or unless I'm really sick or really hurt and I can't get in the water, then I will be in the pool and feeling like and feeling like myself afterwards. I'm a better person for having done it. And also, I love cookies.
Cookies.
And that's actually that's not a joke. I love cookies. I inhale them and I do that every day. And if I don't swim, then, it's just going to have an adverse physical impact on me. So, yeah. So it allows me to afford that.
Mark Price, hand up. I'm sorry. Mark Price, hand up. Let's bring you in. You got a question for us?
Hey, Bill. Hey, Jeff. I've got my own little Snoopy guy. I got my Snoopy Peppers here. I collect Snoopies as well.
Well, isn't that a coincidence? Who does
no,
that?
It's not. I've had a situation come up where the family, there's 4 siblings, and the mother and father decided to give it to the person who they thought was the most stable sibling, because one was bipolar, the other one was had some deep psychotherapy issues that needed to be taken care of, and the other one was an alcoholic. Mm-hmm. And the 4th one was just a busy guy all the time in technology. So, we can call it late adults at ADHD. Mm-hmm. But anyway.
Yeah. Okay.
What the attorney and what the clerk of court wanted us to do was to be their referee. And it's something that I wanted your opinion on as to how you would step into that and say, look, this really needs, this is really outside of my purview. What do you think about bringing in some other kind of specialist? Because this is not something that we can do as a state specialist.
Okay. Matt, are you talking about a trust or a plan that says that when the parents die, all the assets go to one child for hopeful distribution to the other children? Are you talking about the office, the capacity of the successor of the delivery boy, the successor trustee after both mom and dad pass? Is that what you're talking about?
After mom and dad passes, it's just a will that says this one person has to split everything up, but everybody thinks that there's more there than.
No, I get it. So they named, there's 4 kids and they named one to be the after death delivery boy.
Right.
Their after death agent. And they based it on and they based it on reasonings that they felt made sense to them.
Right.
One has ADHD, one is maybe financially immature, one is too busy. So they name someone, and now that it has the role of carrying out those instructions, which say all the assets in equal shares to everybody. I'm assuming.
Correct.
Okay, so that's that's a lot of power for that one successor trustee, that one delivery boy, because that person in power now gets to decide what each of their shares will consist of. And because the trusts usually say that there's always there's a provision there. It's pretty standard boilerplate, and it says in a nutshell that the trustee has the power to distribute assets to each beneficiary pro rata or non pro rata, which is fancy legal language saying as long as everybody's shares are equal, the trustee can decide what those shares will consist of. Well, maybe the beneficiaries will say, hey, we don't, that's not what we want, to even split in everything, or we don't want those assets. Those assets are going to not appreciate in value in a million years, or something else like that. So now the question is, this person, what does he or she do? Well, solicits the opinion of the others to say, okay, this is what I want, don't want. Now you have a lot of competing desires. So I see the problem. It's a lot of pressure. Am I defining the circumstance adequately? Is this what's going on?
Well, the one who had ADHD was the executor, and the other three had more serious issues.
I see. Okay. All right. All right.
The
Sorry,
executor asked the executor
okay.
asked the attorney to step in and help with trying to keep the herd corralled.
Yeah. Well, beneficiaries, it's being the trustee, being the executive, it's fraught with with people with liability. If a beneficiary doesn't like the proposed distribution or how the trustee is doing his or her job, they can be, they can sue him. I've got a situation right now where there's two sisters and they're absolutely battling each other over everything. And one of them is the trustee, and that's my client. And every single move that my trustee client makes is challenged by the other sister who's the beneficiary. And a trustee has fiduciary duties to that beneficiary to administer the trust estate with loyalty and not without bias, which is tough to do when that trustee is also a beneficiary. So that can all be called into question, and some disgruntled beneficiary or, just out of pure family baggage, negative family history, can get a lawyer and, try to motivate that trustee to do what he or she wants, what the beneficiary wants to do. So getting a third party involved, that's not a bad idea, because now there's a sounding board out there that the trustee can use to say, well, this is based, the decisions I'm making are based on this information, and it's an informed decision by someone who does this every day. So
right, a third party.
It's not a bad idea. It's kind of like going to a mediator, someone who's versed in this area, someone who's maybe a private fiduciary, who's in the business of being a trustee. Like there's a group called California Professional Fiduciaries Association, and these folks are in the business of being trustees. So sometimes the trustee is ultimately responsible from a liability standpoint for all the decisions made, but the trustee certainly can consult whoever he or she wants in order to make those decisions, whether they're investment decisions, distribution decisions, tax decisions, whatever. And and that's fine. That's fine. I've got a client who's a trustee. He's terrible with money. He doesn't know anything, but he can consult with people who are well versed in that. So I think it's absolutely fine for a trustee who is not experienced or is nervous or is concerned about his backside or her backside to consult with someone who knows more than what he does. That's a fine decision. Whether those decisions will be accepted by the beneficiaries, well, that's another issue. And some disgruntled beneficiary will say, no, I want this instead of that, or whatever. Then that's what.
Yeah, at that point in time, it got up there to the courts, and I turned around to the four of them and I said, look, every time that you file something, it costs you money.
Yeah,
So don't be surprised if there's nothing left.
that's true. That's when a beneficiary files an action against a trustee, the trusts have a provision in there which say that the trustee can attack, the trustee can defend
Mhm.
against that attack of the trust or the trustee's duties, unless the trustee is engaging in fraud, and use trust estate funds for that defense. So if that goes on for a long time, then that diminishes the amount in the trust estate for distribution to the ultimate beneficiaries. Absolutely.
Right.
And that's explained to the beneficiaries, but if the beneficiaries have an axe to grind, they're just gonna, say, we don't care.
They're
We
gonna
don't
grind
care.
it.
I've had a trust estates diminish significantly over battles over the personal property distribution. That's the stuff where the opposing lawyers are looking at each other, across a desk, and saying to them, with eyes that say essentially, can you believe this is what we went to law school for? I got that right now. I got that. And this other attorney, he's got to go along with the program of what his client wants. I get this lawyer's letters, and these lawyers' letters are filled with venom, putting on a show for his client, saying, my client wants this hutch. My client wants this, these Olympic pins from 1984. I'm not kidding. This is real, and we don't get those, and we're going to, file an action, whatever. And I know for a fact that is public relations for the client, because I've talked with this attorney and we're saying, can you believe this? So, it's, this is the fallout, from family baggage, but there are ways around it. There are ways to draft around these kinds of problems. So anyway, I digress. I go on, I got a million stories and, but there you go.
Thanks, Matt. Thanks so much. Appreciate it. So look, we're kind of at the end here. So what I want to do is first thank Jeff. We this was a little bit more in the weeds of the technical side of your business. Oftentimes we talk about the business, how do we do business development? But I think really what you gave us today was a real flavor of what it's like, so that when we work with attorneys, when we're selling real estate, we can speak the language a little bit. We can understand the problems, understand the depth of it. Sometimes, we send things to attorneys to get the customers to sign, and we get it back in an hour because there's four parties involved. It's more complicated. As realtors, we expect things done right away, and we move on realtor time, and attorneys, unfortunately, have clients they have to deal with, and it doesn't move that quickly. So just, I just want to thank you personally, Jeff. You've been a good friend, but also a great advisor and teacher for all of us on this call this time or previous times. I want to tell you how much I appreciate you taking time with us and share, you appreciate it.
You are the great Bill Gross. You are a great guy. You are the king of marketing, and you have referred me to various places to eat and to buy Judaica, and we have followed your advice, and we've never been disappointed.
Thank you.
The topic that you bring, which is the probate sales, you're so good at it. Coincidentally, I've had a number of probate sales lately, and what's fun about them is that I've been doing them remotely, and which is kind of unusual to hear, because especially when you have to sort of be present to try to qualify potential overbidders who show up in the court.
Right.
So now what I'm doing is, because I'm appearing remotely, you got the brokers showing up, and the brokers, I actually give little lectures to the brokers and say, okay, I'm here, you're there. You have to actually find the nerve to stand up in the courtroom and say, are there any overbidders here? And then they themselves will go out and qualify them in the hallway. But in each of those situations, I think I've had 3 remote, since the whole pandemic thing began, I've had 3 remote court sales, but none of them have had overbidders. So we haven't had any situation where the brokers actually had to see if they can get, if the certified check's there for $1,000 over the, over the overbid amount, for, increments of 1,000. But that day will come. So we'll see what happens.
Well,
interesting time.
Well, I again, appreciate the chance to work with you and your insight and your support. And thank you so much.
Oh, you got it, Bill. Anytime.
Thank you. Thank you so much. And for the rest of you, we do this every week. Probate Weekly, we do it Thursday, 4 p.m. Pacific, 7 p.m. Eastern. We usually live stream it on YouTube and Facebook. We had a little technical issue this week as I'm out of town, but appreciate you guys' support and questions. And Jeff, if somebody want to get a hold of you to talk about estate planning in particular, now what I don't want is every realtor on this call to call him up and solicit his business, because that's just not how it works. But if you have a specific estate planning client, or if you are an estate planning client that you think is appropriate for Jeff, how should he reach out to you to talk to you about that and see if that makes sense?
Oh, okay. Well, thank you for the opportunity. I forgot all about the fact that, yeah, there's actually a business end to appearing on your show, but I enjoy it so much that I forget about that. My name is Jeff Condon. You Google me. I'm in the book. That's an old folks phrase. I'm easily findable because of the 2 books that I've written. You Google Jeff Condon estate planning, I'm going to show up like about 35,000 times. I'm in Santa Monica. My phone number is 310-393-0701. That number again, 310-393-0701. You call me, you chat with me, you email with me. There is no charge for that first encounter, however that is, whether it's Zoom, email, in person, on the phone. Happy to do it. Love talking to people, love helping people. This is what I do. Please take advantage of this offer from an attorney to talk to that attorney for free, because a lot of people go, what's the catch? There is no catch. Talk to me. I'm fine with that.
And we'll have the description as well, both the link to your website and to your phone number. And then if you go see Jeff, make sure you bring something with a Snoopy on it if you want to get in his good graces. So, yeah, Jeff, thanks so much. I appreciate you so much. And everybody, Thursdays, 4:00 p.m., Probate Weekly. Thanks so much. Subscribe if you like to see this regularly, and we'll talk to you guys soon. Thanks so much, everybody.
See you at the pool, Bill. See ya.
Thanks. Jeff. Okay, bye-bye.